Good morning, ladies and gentlemen. This is day 24. It's so excited to know that we have actually gone this far. That's because of the supports that you all have exhibited, and of course, your interest in your continuing legal education, or we will definitely enjoy the series together during this MCO period. Now, this is actually a rerun. We had this employment topic a few days ago, and there was a technical glitch then, but then we managed to sail through, and we extended the session to about an hour. And many questions have, were answered, but there were still many more that we did not have the time to deal with, and that's why, and due to demands, actually requests from a lot of our audience to have another session. So we have decided to hold a rerun today. But even though it is a rerun on employment topic, but there will be many more issues that the speakers will be able to deal with today, which they could not at the last session. So don't worry, there would not be many duplications. But for those who have actually missed it, don't worry again, because the video of the session had already been recorded and it's now been uploaded on YouTube. All you need to do is that you go to YouTube and type L2 construction, and it will actually bring you to that particular series of sessions that we have recorded and uploaded on YouTube. Once again, thanks for your support. As of now, we already have 240 audience. As usual, this number will continue to grow in the next few minutes, as what happened in all our other series. Now, you have, for those who have already attended the first session, you already know who our special guests are. He is Mr. Donovan Cheah, the partner and the principal partner of the law firm named Messrs. Donovan and Ho. And together with him is Mr. Rohan Arasoo Jeyabalah, who is also a partner of Harold Lam Partnership. That is the firm I'm from. And today, myself, Lam Loon, and my host partner, Leong will be moderating the session. Without further ado, I will pass the mic to Donovan to start his presentation. Donovan,
right.
over to you.
Thanks a lot, Loon, and good morning, everyone. Thanks for spending your morning with me to talk about some of the challenging issues that all of us as business owners are facing due to the MCO and even arising from the COVID-19 situation. Now, Hongkit, if you could go to the first slide. Next slide, please. All right, so I think I'll go straight to the point. I think one of the burning questions that a lot of employers have is, how are we going to do cost cutting during this period? Due to the MCO, operations have ceased or suspended temporarily. Costs are still going up. We still have to pay our employees. Staff cost remains the same or can sometimes even increase. So employers are looking to try to reduce the burden on their overheads and expenditure during this difficult time. And the obvious angle that they look at is salary costs, because for most businesses, salary costs will comprise a large amount of their overhead expenditure. And with revenue not going up, or in some cases dropping to zero altogether, this is really an important issue for many employers in Malaysia, and not just in the construction industry. Now, typically the three main things that everyone is asking about whether they can do these things would be the options that are on the slide. Okay, number one would be pay cut or salary reduction, where you reduce the percentage of your staff's salary by a certain amount in order to cut your costs. Unpaid leave is where you put your employees on leave and you obviously don't pay them during this period because you're not going to be working. That is another way of you cutting your salary costs. And lastly, there is forced annual leave, okay, where you ask employees to use up their annual leave during the MCO period so that you can reduce their annual leave balance. Now, pay cut and unpaid leave is quite obvious in terms of how they impact your costs and your bottom line, because it's a direct saving if you manage to implement it. Annual leave is another way of cost saving, because some companies, depending on how you run your business, will have financial provisions for employees' annual leave balances. This is in the event where the employee resigns or is terminated. Normally, you have to pay out their accrued and unused annual leave. So asking employees to use their annual leave during the MCO period, especially if they are not working, is one way of kind of saving your costs in the long term, where you reduce the annual leave balances of the employees and free up your financial provisions to use for other operating expenses. So these are the three normal options that employers are looking into when they want to reduce their salary costs. So commercially, that all makes sense, but the burning question, like I mentioned, is can you do this legally? What does the law say? Okay, when we talk about the law, we look at the Ministry of Human Resources first, which is the authority about labor relations in Malaysia. Now, the Ministry of Human Resources has issued some guidelines, and it's all available on the internet on their website, which states in summary that you cannot do any of these three things unless you get your employees' consent. Now, this, in my view, is also consistent with employment law in Malaysia. And the reason why you need consent from your employees or agreement from your employees to do these things is because all these three things affect your employees' contractual rights. Now, when you enter into an employment agreement to hire your staff, it is a term of the contract that you will provide them certain things like X amount of salary to be paid every month. You will also provide them annual leave entitlements and whatnot. So when you try to change any of these terms, it actually, like any other contract, it amounts to a variation. So if you do an analogy like in the construction industry, where you agree to do certain things, if you want to do something else outside of scope, you have to do like a variation order and get the approval of your the contractor, so, or the employer. So this is pretty much the same concept. It is just like any other contract, an employment contract. Once you agree on the terms, if you want to make any changes, you need to get consent. So if you don't get consent of your employees, you do have some legal risk involved, because employees will have a right to claim breach of contract, or in some extreme cases, they may even claim constructive dismissal. Constructive dismissal is a situation where the employee quits in protest. They say that you have changed the contract beyond what they agreed and they can no longer work with you. And it is equivalent to terminating them directly. So they can actually sue you in the industrial court for constructive dismissal if you make big changes with their contract without their permission or consent. Hongkit, next slide, please. So now that we know that legally you need consent, the next logical question is, how should you ask for consent? How do you get employees to do these things? Now, coming from a legal perspective, it is always important for you to get everything in writing. So we would always recommend that if you are going to implement any of these three measures, you should ensure that it is put in writing and the employee's consent is also recorded in writing. You don't need a formal agreement. You don't need to go and enter like some variation contract or like a special document, it's like variation order, anything like that. You can just actually issue an internal memorandum, like a HR policy or HR notice, to all your employees and ask them to confirm their agreement in writing by signing on the copy. So of course, if you do this during MCO physically, they're not going to be able to sign the document and pass to you. Electronic signature is fine, or even just replying to the email and say confirm, accepted, whatnot. All those are accepted evidence of employees' consent. Now, you can also put in your memorandum, if you're going to predict that there's going to be some difficulty about employees replying to you, you can also put in the memorandum that if you don't respond by a certain date, we will take it that you have no objection. So this is a way of getting implied consent. So as long as you have proof that you've notified the employee and they actually didn't make any complaint, and they even, let's say, receive the reduced salary at the next payroll without complaining, all those factors can be construed as consent as well. Okay, so but before you actually just send out one random notification like that, I think it's also important for you in terms of employee communication to speak to your employees. So now, because of all this technology that we have available, like currently right now we're all using Zoom, you can even have like a town hall discussion with your employees virtually using video conference to just brief them about what's going on with your company, what measures you are planning to take, like the cost cutting issues, and explain the reasons why you need their consent or you need their cooperation in order to do these things. So when you give a background and you give reasons for why you're doing something, you're also more likely to get consent from the employees as they will understand the reasons why you're doing it. It's also a little bit more compassionate in terms of explaining the situation to employees. It will work really well in terms of just getting employees to be on board with what you want to do. Because if you just send out a random notice like that, it can be seen as very cold, and employees may not even know what's going on, and they may feel very worried or concerned about whether they should be agreeing to these kind of things. So try to look into having some sort of town hall or team meeting, team discussion, virtually or otherwise, with your employees, kind of just to set the tone before you start issuing all these internal policies and memorandums. Okay. Hong Kit, next slide, please. And before I go to this point, in terms of other ways to get employees' consent, as long as you have proof, it is fine. So I saw a question just now about WhatsApp. WhatsApp messages is also fine if you can send your communication to employees by WhatsApp. You have proof that they've received it and they replied. That can be treated as consent as well. Okay. Now, the next logical question again then will be, okay, it's very fine and easy to go and ask employees for consent, but are employees going to consent? Are you going to get a situation where all your employees agree to just take a pay cut or agree to go on unpaid leave without any problems? Realistically, if you have a large workforce, the chances of getting unanimous consent, of course, is quite low. You may have one or two or maybe like a few percentage of employees who are really concerned about the measures that you want to implement, and they may not be so cooperative or agreeable. So what happens if you do everything you're supposed to do, you ask your employees, and then they don't want to consent? What does it mean for you as a business? All right, so when your employees don't consent, you have two main options. Number one is I would say the really aggressive approach is just push ahead with your cost-cutting measures anyway, regardless of the fact that you didn't get full consent. This, of course, like I mentioned, will carry some risk of the employees claiming that you have breached the contract, but you have to do your risk assessment, because in this economic climate, the real question is, are employees going to quit their jobs and sue you in court just because you reduce their salary, let's say by 10 or 20% during this very obviously difficult time? Okay, job security is still very important. Employees, while they may not be happy with the pay cut or the cost-cutting measures that you've taken, they may also realize that job security right now is more important in the long term. So you do have to take your risk carefully, assess it. Do you think whether your employees are the type that will really litigate over issues like this? If so, then you factor that into your risk assessment. If you think that employees are just kind of raising concerns but not going to object very strictly or strenuously, you can consider just implementing it unilaterally but taking the legal risks into account. The other option is that you look at the employees who have not agreed and you leave it as status quo for them and implement the measures for those employees who have agreed. Now, of course, this in a way may be seen to be the legally safe approach because you're not forcing any employee to do anything that they don't want to do. But you have to think from a moral perspective, it could appear to be very unfair to the employees who have cooperated with you. Because what you are essentially doing is that you are only reducing the pay for those people who have cooperated and said, yes, okay, you can go ahead and do it. And those people who, let's say, cause problems and are very disagreeable about it, you keep their salary at the current level. So of course, this may not seem very fair to the employees, but I think what you have to explain to your employees is that if they don't agree to the measures that you're looking at, it is quite likely that you will not be able to achieve the cost savings that you require in order to keep your business afloat. And when you don't achieve the cost savings that you need, there may be a likelihood of you taking more drastic action, such as retrenchment and downsizing. And that means terminating employees simply because you cannot afford to keep them anymore. And that in the long term is actually a lot worse than taking, let's say, a temporary pay cut for a few months, or even just going on unpaid leave for a few days, a month, or whatnot. So you have to weigh these two options very carefully and decide what is actually best based on how you predict your employees will react. So you know your employees best. You have to weigh the risk involved accordingly if your employees don't consent. Next slide. Okay. Now then, since we talked about what happens if you can't achieve the cost savings involved and you really need to do something desperate like downsizing. Everybody doesn't want to do this, but it is an economic reality that if you cannot sustain your workforce anymore, you have to downsize. And that means you have to let go of some people who are surplus. So the question that we as lawyers always get is, can I retrench employees during MCO period and also due to COVID-19? Okay, the short answer is yes. There is nothing preventing you from downsizing or dismissing your employees during MCO. The Ministry of Human Resources has actually issued their guidelines as well to say retrenchment is possible. It's fine to do it during COVID-19. The only thing that it is really important for you is to make sure that you comply with labor law regulations when you do your retrenchment. So what are these legal requirements? Okay, the legal requirements are you need to have a genuine redundancy, which means that the employees that you want to get rid of are really surplus to the needs of your company. This could be due to things like loss of profit, loss of revenues, no more projects, etc. Okay. The other thing is that the way you select your employees is really important as well. For example, the Ministry of Human Resources, their guideline states that you should apply foreign worker first out, or FWFO, which means that if you have a group of employees holding the same post and you need to get rid of a few employees, you should select the foreign employees first and try to protect the jobs of the Malaysian employees. So that is the first step that you need to look at. If let's say you don't have any foreign employees or the category of workers you want to terminate are all locals, then the recommended approach is you have to use LIFO, LIFO, which stands for last in, first out. That means that if you have to select employees for retrenchment, you choose the one that is most junior in terms of length of service. So when we talk about junior, we mean length of service, the person who has come in later or last in. Okay, once you do that, that is an objective way of selecting employees for retrenchment. It is also possible to not use any of these options that I mentioned if you have a good commercial reason to do so. So some employers, they may say, I don't want to use last in, first out because the person who joined later actually is a really good staff. And the one who has been working with me for 2-3 years already, they are the ones that are actually quite difficult, or they're just slacking about. They're not really the top performers. So I would rather keep the ones that are hardworking and good performance, whatnot. So you can depart from using LIFO if you have a good commercial reason, but the requirement is that you must have an objective basis for selecting these employees. All right, so giving a reason like the employee is difficult is probably not a good reason to depart, but you can take into account performance objectively by doing things like checking their last few performance evaluations. You can choose the employees who have the lowest score to retrench, even though they may not be the last in, or you can even set criteria like all employees who have received the warning letter before, they will be the first one to go, rather than looking at length of service. Okay, so that's one way in which you can actually do your retrenchment. And again, like I highlight, it is legally fine to downsize during this period as long as you comply with legal requirements. Hongkit, next slide, please. So now the important question is, are you going to get any help from the government if things are difficult? And most of you may be aware the government has implemented a wage subsidy program to help employers cover the cost of salary of certain employees. If you can go to the next slide. So the slide here will show you briefly how the wage subsidy program works. I won't go into the minute details, but essentially this applies for employers who have employees who are earning monthly wages of 4,000 ringgit and below and are registered with per CASO. And as long as your business has been registered before 1st January 2020 and have been operating before 1st January 2020, you will get paid a certain amount of subsidy per applicable employee, depending on how big is your company. So just looking at the slide, for example, if you have less than 75 workers, you get 1,200 ringgit per applicable employee. And if you have more than 200 workers, you only get 600 ringgit. Now, for smaller companies who have 75 and below employees, you don't need to show any loss of revenue. But if you have more than 76 workers, you must show that you have suffered a drop in revenue of at least 50% from January 2020 compared to subsequent months. So you can prove this by just adducing your financial statements or sales reports, as long as it's certified by a manager of the company. So no need to get it externally audited or anything like that. You'll be required to sign a declaration to Perkeso that the documents that you submit are true and accurate. So if you make any false information inside the form, you will be liable to legal action by Perkeso. All right. Next slide. So this is sounds very nice. You know, we're all going to get money from the government, but essentially, are there strings attached? And the answer is yes. So, like I stated in the earlier slide, this subsidy only applies to certain employees, those who are earning 4,000 ringgit and below. It doesn't apply to all your employees. So if you are applying for the subsidy for certain employees, you have to understand that during the wage subsidy period, which is 3 months, you cannot reduce this employee's salary or retrench them. All right. So, and you cannot do it for a period of 3 months after. So you'll be looking at a total of 6 months where you are stuck in terms of this employee's salary, and you also have to keep them for a minimum of 6 months. So if you violate the rules, you can also be subject to, it will be an offense under Perkeso, right? So what you need to do as a business, if you need to do a financial assessment, count the number of applicable employees you have, look at the subsidy they are going to receive, and do an evaluation whether this subsidy is going to help you stay afloat for the basically 6 months. Because if you feel that it is not enough, and after 3 months or 4 months, you are still likely to want to have to retrench certain employees, especially those applicable employees, you may want to actually forego applying for the wage subsidy and keep your right to take cost-cutting measures or downsize before you apply. Because once you apply, you will be literally, like I mentioned, stuck for 6 months. So be very careful when you are applying for the wage subsidy. Don't take it for granted that it is free lunch. Okay, so everything comes with conditions. Be mindful what they are and do your financial projections before you happily go and apply for money from the government. All right, so those are the main issues that I want to cover during the presentation, and I think we can take some Q&A from the audience right now.
Okay, over to you.
Okay, thank you, Donovan. I'm glad you finally finished your unfinished presentation. Okay, let's now begin our Q&A session. I will start with Rohan. Rohan?
Yes, thank you, Hong Kit.
Hi, hi Rohan. Welcome back. So Rohan, last week you told us in a construction project, each company has to obtain a separate approval to resume work. That means, for example, if a project site has 1 main contractor and 4 subcontractors, that would have a total 5 approvals. Am I right?
That's right, Hong Kit.
Okay. So based on the current approval system, is it possible that a subcontractor obtains approval to resume work, but the main contractor does not?
To answer that, it's no, Hong Kit, because recently, MITI, in issuing their FAQs, following the decision by the government to allow certain sectors to open up during phase 3 of the MCO, has stated in their FAQ that the main contractors in the construction industry will first have to submit their application for approval to operate. And it is only upon approval being granted to the main contractor can the subcontractor then submit their application for approval. So if we are faced with a situation where the main contractor has not obtained approval to operate for a particular project, then it is unlikely that the subcontractor is going to get approval because the works are going to relate to the same project. Yes,
Yeah, right. That makes more sense. Otherwise, we would have an awkward situation where subcontractor is allowed to work, but not the main contractor. Rohan, so if a main contractor obtains approval to resume work, but his subcontractor, perhaps out of the fear of the spread of virus or unwilling to take risk or liability, refuses to apply for approval to resume work. And this, of course, will obstruct the main contractor's progress. So in this situation, can the main contractor impose LAD or enforce other contractual rights against the subcontractor?
This is a very interesting question, Hong Kit. And the answer to this question is actually not so straightforward. Let me just tackle this from an employment perspective first. Okay, now given that the government has allowed certain sectors to open during phase 3 of the MCO, including the construction industry, does not necessarily mean that if you are a party in those listed sectors, you must apply for approval to operate. As an employer, it is your prerogative as to how you want to run your business, how you want to manage your business, as long as you do it in accordance to your employment obligations and there is good labor practice. So it is well within your right as an employer to choose not to operate during the MCO, for example, due to health reasons. So long as at the end of the day, you do not deduct the salaries of your employees, you do not force them to go on unpaid leave, or you do not terminate their services or lay them off, then it is perfectly fine. But that is from an employment perspective. But insofar as contractors are concerned, the situation is slightly different insofar as your contractual obligations are concerned. Now, as a contractor, of course, you have time obligations under your construction contract. And in most construction contract, if the contractor is prevented from performing its obligations under the contract, they may be entitled to time. And like, for example, now we are faced with the COVID-19 outbreak and also the MCO. Under certain standard forms of contract, the contractor may be entitled to an extension of time. You may possibly be entitled to rely on the force majeure clause. For example, the PAM form of contract 2006 and 2018, the force majeure clause caters for events such as epidemics as well as governmental action. Now, can a contractor rely on governmental action if there's such a provision in the force majeure clause in their contract? I would now say no, because the government has given you that opportunity to now operate during the MCO, and you have chosen not to operate. So you may not be able to rely on that, that part of the force majeure clause. And insofar as epidemics or pandemic is concerned, again, the question is this. Even though there's a pandemic, there is this COVID-19 outbreak, there is actually nothing to stop you from going on to carry out your works, because now you can actually submit an application to MITI and you are likely to get approval to proceed with the works. So you are not prevented from actually carrying out the works on site. Unless, of course, you're faced with a situation where perhaps your project site is at a red zone, where there are many reported cases of COVID-19 and still a very serious risk of your workers contracting the virus if you were to open up and allow them to go onto site to carry out the works. But this is something I think that contractors would have to be very mindful of if they decide not to operate, although they have the opportunity to operate during phase 3 of this MCO. So they could potentially face liability for delay from their main contractors if they choose not to proceed with the works at this time. And I think this is more of a construction issue rather than an employment issue. And perhaps either Wailun or you may also have some views on this issue, Ankit.
Yeah, I agree with you, Rohan. This is really not a straightforward question. It has to be considered from many angles to make a decision whether to resume work or not. So perhaps, Wailun, do you want to give your view on this?
No, I don't have here.
Okay. Rohan, I moved the question from the subcontractor's context to the employee's contract. What happens if a site manager of a contractor company which obtains approval to operate but refuses to return to work at site?
Okay, in the event, as the employer, whether you're the main contractor or the subcontractor, or you are in any other industry, you have obtained approval from the government to proceed with your works during this phase 3 of the MCO, and you have already submitted the list of names of your employees whom you wish to report to work during this period, and those names have been approved by the government, then it is reasonable, fair and reasonable for you as the employer to expect your employees to report to work. So in the scenario that you have given, it would be unreasonable for the site manager to then refuse to come to work unless the site manager has a valid reason for not wanting to come to work. For example, he has a health condition, he has been certified unfit by the doctor to attend work. Only in those sort of situations, or if the site manager, for example, is living in an area where it is currently under total lockdown and is not allowed to leave his home, then maybe he's excused from coming in or reporting to work. But other than that, he would be expected to report to work. And if he does not report to work, he could be considered to be in violation of his obligations under his employment contract. And the employer may then take the necessary action as merited under the employment contract, maybe can even subject the employee concerned to disciplinary action. Yeah, that would be my answer to that question, Hongkit.
Okay, Rohan, my last question to you. If an employee wishes to file a claim with the Industrial Relations Department after he or she has been dismissed because of the MCO, is there any timeline for him or her to do that?
That's a good question, Hongkit. Under our current laws, under Section 20 of our Industrial Relations Act 1967, any employee who wishes to make a representation to the Industrial Relations Department for unfair dismissal or constructive dismissal has to make that representation within 60 days from the date of dismissal. This is a mandatory requirement. There are no exceptions. So for example, if the employee files the representation on the 61st day after he or she has been dismissed from employment, the industrial court has no jurisdiction to entertain the employee's claim. And courts have also decided this issue. It is very clear, there are no exceptions. However, it should be noted that following the implementation of the MCO, the Ministry of Human Resources, in one of their FAQs, have stated that the MCO period will not be taken into account in computing the 60-day time period for an employee to file their claim for unfair dismissal or constructive dismissal. So for example, if you're an employee and you have been unfairly dismissed by your employer during this movement control order period, your time to lodge a complaint, or rather the time for you to make a representation to the Industrial Relations Department, will only run after the MCO is officially lifted by the government of Malaysia. But I would advise that employees be very careful simply because of this. As it stands, the FAQ issued by the Human Resource Ministry does not really have the force of law. And statutorily, you are required to file your claims within 60 days from the date of your dismissal. So you do not want to be caught out in this situation where later there may be jurisdictional challenges raised. And as it stands, there have been no amendments or subsidiary legislation that has been passed extending this period for you to lodge a claim. So, and in fact, even during this period, employees who wish to make representations to the Industrial Relations Department can do so by way of an email to the Industrial Relations Department. Yeah, so that would be my answer to your question, Hongkit.
Thank you, Rohan. Thanks for answering. I will now pass the mic back to Loon.
Yep. Yes, Hongkit, thanks a lot.
Over to you.
Yep, sure. I have questions for Donovan though. Donovan, are you there?
Yeah, I am.
Donovan, I have a few questions which I picked up from the chat room.
Mm-hmm.
Now, when you were talking about the agreement to, for example, reduce salary, or take unpaid leave during the MCO, or perhaps also utilize the annual leave during the MCO period, right?
Mm-hmm.
And then you said that you need agreement from the employees before the employer can implement those pay and etc.
Yeah.
Now, and you also said that it can be by way of memo, and then you just need a confirmation from the staff to agree, not to agree to the proposal, let's say to a pay cut.
Yeah.
Now, would WhatsApp be recognized? You just said I agree, yeah?
Yeah.
That would be one of the questions that they have asked.
Yeah, WhatsApp is fine.
Okay. Now, the second question is that is there any restriction as to the period, as to when the pay cut can be enforced or agreed upon between the employer and the employee?
Yeah, so there is no legal restriction as to how long you can impose a pay cut. So as long as you get employees' consent, it can be for any amount of time. But normally we would recommend that you give employees a time frame, an initial time frame, and you say that we can revisit this after, let's say, 3 months or X number of months, so that they at least have some visibility about what's going to happen, and they can also make their own planning. So there's no time limit per se.
Okay. And then does it make a difference between permanent employees and contract employees when it comes to this approach?
No difference. Again, contract employees or fixed-term employees and permanent employees are treated as the same in terms of their employment rights when you come to vary a contract. So similarly, you still need to get consent as well.
I see. So let's say if the employer decides to exercise retrenchment, rather than pay cuts, and they want to retrench employees already because there's excess, and there's also commercial reasons why certain people are no longer needed for the organization. So in such a situation, is it mandatory that the employers will have to pay employees the termination or the layoff benefits? Is it mandatory?
Yeah, so this depends on the workforce that you have. So for certain employees, basically those who are earning their wages do not exceed 2,000 ringgit a month, or any employees who are involved in manual labor, regardless of salary. These types of employees, there is a statutory requirement or a mandatory requirement to pay them termination benefits if you retrench them. The termination benefits for these employees will depend on the length of service. It is basically ranges from 10 days of wages per year of service up to 20 days of wages per year of service for an employee who is working longer than 5 years. So for example, if an employee who has worked there for 6 years and he falls under that category, you need to pay him a minimum termination benefit of 20 times 6, which is 120 days of wages. So this start payment, it is not negotiable, and it doesn't matter whether you are financially able to pay or not, because it is a legal obligation to pay for this kind of employees. For your other employees, for example, those who are earning above 2,000 ringgit and they are not involved in manual labor, like those office staff, admin staff, all that, there is no mandatory requirement to pay, but usually it is recommended that you do give some sort of termination benefit or severance pay to these employees to help cushion the hardship that they are going to face with the loss of income. Because if they challenge your termination later and it goes to industrial court, one of the things that the industrial court will look at is whether you are acting fairly enough and whether you gave termination benefits even if not legally required. That's one of the relevant factors. So we do encourage payment, and you can make payment along the same lines as those employees that we've mentioned, the 10, 15, 20 days.
I see. Okay. So let's come to probationers, those under probation.
Yeah.
Now, during the MCO period, obviously they are not working and they are also not recognized as permanent employees. First question is that do you need still to pay salary during the MCO period when they are not working? And secondly, what about their probational period? Would that be automatically extended because of the MCO period?
Yeah. So number one, payment of salary, yes, you still need to pay. probationers are, in terms of their legal rights, are like any other employee when it comes to salary. So same thing, you have to pay them unless you get the consent. You cannot reduce the salary as well unless you get consent. Number two, in terms of the probationary period, under the law, even without MCO, if there's a probation period and you did not give a confirmation letter at the time the probation period ends, it is deemed that the probationary period is automatically extended. Okay, but best practice, we always advise, don't rely on automatic extension. You can actually tell the employee that I'm extending the probation directly. So you can actually write a letter to the employee and say that, look, due to the MCO period, which is now already like how many weeks, we haven't been able to assess your performance fully, as you know, you've not been required to go to work. So to be fair, we are going to be extending your probation period for an additional 6 weeks, whatnot, and your new probation period will end on this date, where we will inform you whether you're confirmed or not. So we always recommend just let the employee know what's going on. Don't keep quiet and then later on you rely on things like automatic probation extension, because the employee may not know and they may not understand where they are at.
All right. Yep. Donovan, I'm going to go back to the pay cuts issue, because a lot of questions were asked about the pay.
Sure.
Now, talking about pay cuts, right? Talking about strategy and the problems that you're going to, and the challenges that the employee is going to face. Let's say you have a scenario whereby there's a bunch of employees who do not wish to agree to the pay cut, and the rest, the other group actually agree. Now, how do you then treat these employees who have refused to agree to the pay cuts?
Yeah, so I think like what I've mentioned earlier, the important thing for the company to assess first is, number one, how many of these employees are objecting? So how big is this group? Because if it is a majority of the employees, then I think the company may be better off not implementing the measures as a whole, even for those employees who consented, because you may be looking at a situation where like 80-90% of your employees refuse. I think it is an issue of morale and all that. You may want to look at not implementing the measures at all, because you may end up with 80-90% of disputes going on. So that is one issue. If it's just like 1 or 2 employees, then the options that are available to you, of course, is like I mentioned, just push through anyway, impose the measures, even though the person didn't consent, but bear in mind there could be a risk, but you're kind of like calling the employee's bluff, that they may not going to go and incur the cost and go and file a claim just because of a salary cut. So you have to kind of like be comfortable or have a good enough risk appetite that you're comfortable with that. If not, then you just treat this group of employees differently. You don't make any changes to your contract, but bear in mind there's some unintended consequences arising from that. Your other employees are really not going to be happy about it, that they helped you out and were cooperative, and yet they were the ones with the pay cut. So you just have to weigh these 2 options.
Now, let's talk about strategy here.
Yeah.
Donovan, what if the employee to say that, okay, he foresees that there's going to be some problems, then he can actually target certain departments which might be easier for them to approach with a different reason. So would they be able to do that selectively, to have a pay cuts rather than pay cuts across the board?
Yeah. So selective salary reduction is possible. The typical ones that we've seen are salary reduction, actually differing amounts based on, let's say, rank or department. So the common one is that, managerial level will take a higher pay cut, and lower level employees will not have a pay cut or have a very small pay cut. So depending on the band, it is also possible to go by department. Let's say if certain departments are not generating revenue, let's say if your business unit has your company has multiple business units, different types of projects, and one particular department is the one that's suffering, you can look at zooming into that department only, as long as you have a proper commercial reason. So the general rule is across the board, of course, is the fairest way. But if you have reason to kind of choose selectively, or you have good commercial reasons, you can go ahead. But just be prepared to justify it when employees ask you why.
Okay, Donovan, another strategy. Let's say I have a business. I have various projects and various branches, right? I want to close down certain branches or projects that is not. Then would that be also an option to go ahead?
Close down certain branches, is it?
Yeah, that's right.
Yeah. So that is fine. Again, you can actually, if it really doesn't make any commercial sense for you to keep open certain branches or certain office, you can close down. What you do with those employees, there's a few options. Number one, you can look into whether you can transfer them to your other existing branches or other existing projects. If you can, then of course there shouldn't be an issue. If you really don't have anything available for them, then it's a matter of similarly retrenching them because you no longer need them since the branch is closing down. So then the same principles will apply.
Okay. Well, thanks a lot, Donovan, and thanks a lot, Rohan, for coming to this platform with us again, share your view. I'm sure that, when it comes to employment issues during this difficult period, you will never be able to answer all the queries from the audience. And, we have tried our best to pick up whatever interesting issues or relevant issues for you to give your comments or views on it. We have tried our best, audience, and we have until now more than 350 people who have been with us throughout the entire session. And thank you very much, of course, first to the special guests and also to the audience who have been supporting us. Now over to you, Hong Kit. I think unless Donovan and Rohan, you have any concluding remarks for the audience.
Rohan, you want to go first?
Do you have any concluding remarks?
Okay, my concluding remark would be this. I echo what Donovan has said in his presentation. I think in a time like this, what is ultimately most important is for there to be proper communication between employers and employees. And as an employer, if you want to implement certain measures because of the difficulties that you're facing now, it is important that you discuss them with your employees before implementing any such measures. And from an employee's perspective, it is also important that you understand where your employer is coming from, the difficulties faced by your employer at this point in time. And it'll be great if both parties can work out an amicable solution to the problems faced. Yeah, that would be my concluding remark.
Thanks, Rohan.
Yeah.
Now, if there is no further comments from anyone, Donovan, you have any? Then.
I basically just echo what Rohan has said. We are all here either as an employer or as an employee. Communication is really important from our line of work. When we see cases that go to court from employees, it is usually the employees who feel very disgruntled or very aggrieved, and that stems a lot of the times from poor communication, where they have not been told what's happening. They have been maybe treated very coldly, or they feel as if they're not being appreciated, or if they work with the company for many years, they've just been tossed out just like that. So compassion and empathy, I think, is really important during this time because you need the employees to cooperate with you. So just be mindful of that, legally you can do everything right, but if the employee feels that they were given a short straw, you're going to end up in court anyway. So just bear that in mind when you're implementing all these sensitive cost-cutting measures.
Thank you, Donovan. Hong Kit, over to you.
Yeah, we are grateful to Rohan and Donovan for making their second appearance on L2 construction series to ensure our audience questions are answered. A huge thanks to Donovan and Rohan again. So to help you stay positive and progressive in this MCO, we will bring you Tan Swee Im tomorrow morning for the topic addressing common problems in construction dispute. The last time Swee Im came on board as our guest was day 9 of our series. So it sounds like it was ages ago. Can you believe that we are on day 24 today? So as Loon said at the beginning of our session, without the audience supporting us, there's no way we could have come this far. So please continue to support us and join us tomorrow morning. Thanks for tuning in today and have a productive day. Bye. Thank you, Rohan, Donovan. Thank you,
Loon.
You're welcome.
Thank you guys again. Bye.
Bye.